The court created under the Government of India Act 1935 was the predecessor to the Supreme Court. But its jurisdiction was limited to adjudicating disputes between provinces and federal states and hearing appeals against the High Court decisions. In contrast, the Supreme Court's jurisdiction not only extends to hearing criminal and civil appeals, but also extends to the enforcement of fundamental rights and disputes involving the states of the Indian Federation. In addition, our court can advise the President on important questions of law. The Constitution has envisaged a unified and integrated judiciary with the Supreme Court of India at its apex. The Supreme Court serves the world's most populous democracy and is in true aspects a people's court because it's a collective heritage of the people of India. The Supreme Court's opening session was held on 28 January 1950 in the Chamber of Princes in the Parliament building, where the federal court sat for several years. The inaugural proceedings were marked by an air of solemnity and simplicity. At its inception, the court had a sanctioned strength of 8 judges, but the court started functioning with an occupied strength of 6 judges. During the inaugural session, all 6 judges of the Supreme Court, including Chief Justice Harilal Kania, took their seats on the dais. In attendance were the Chief Justices of the High Courts, the Prime Minister, other ministers, ambassadors, and diplomatic representatives of foreign states, a large number of senior and other advocates of the court, and other distinguished visitors graced the occasion. In his address, Chief Justice Kania prophesied that the court will play a great part in the building up of the nation. Chief Justice Kania's words were prescient. He said, and I quote him, "India has chosen to have a written constitution, and the duty of interpreting that constitution with an enlightened liberality falls on the Supreme Court. The Supreme Court will declare and interpret the law of the land, and with the high traditions behind the judiciary of this country, we are convinced that the work will be done in no spirit of formal or barren legalism. It will be our endeavor to interpret the Constitution not as a rigid body, but as a living organization, having within itself the force and power of self-government." Those were the words which have animated successive generations of judges, including so many distinguished amongst them who are present with us today. In its first year itself, the Supreme Court heard a number of cases related to matters of fundamental rights, including the freedom of speech and equality. As the court began its functioning, several doyens of Indian constitutional law and many members of the Constituent Assembly appeared before the court. The chairperson of the drafting committee of the Constitution, Dr. B.R. Ambedkar, also appeared before the Supreme Court in 1952 in the celebrated State of Bihar versus Sri Kameshwar Singh. Ever since the Constitution was enacted, the Supreme Court has sat in Delhi. A lesser known fact is that the Supreme Court has functioned outside Delhi on 2 occasions, that is in Hyderabad in 1950 and in Kashmir in 1954. On the coming into force of the Constitution, all appeals of Privy Councils in Hyderabad and Kashmir were transferred to the Supreme Court. The appeal records of these courts were in local languages, and their translations would have entailed much expense and time, a far cry from AI-assisted machine translations today. Therefore, the Chief Justice decided to constitute a bench in Hyderabad and Kashmir to hear and decide the pending appeals. In 1954, a decision was taken to construct a separate building for the Supreme Court. The chief architect, Ganesh Bikaji Devralikar, designed the building in the shape of a balance with a pair of scales of justice. When you enter the court premises, you will find the pensive statue of Mahatma Gandhi facing the court building. The court's logo consists of the wheel of Dharma with the inscription, yato dharmastato jayah, meaning where there is dharma, there is victory. These are not merely ornamental imageries. They represent the values of the Constitution and the aspirations of our people. They serve as a reminder for both judges as well as lawyers to act righteously. The present Supreme Court complex was inaugurated by Dr. Rajendra Prasad on 4 August 1958. At the inauguration, Chief Justice S.R. Das presciently laid forth the responsibility of the court when he said, "To us, the new building stands forth as a solemn and sublime symbol of the majesty of the law. The portals of this palace of justice shall be open to every person who may seek redress for wrong, if any done to them, by their fellow citizens or by the state, and justice will be denied to none. The lowliest of the low, be he a citizen or a non-citizen, may as of right claim here equality before the law, and shall receive from this temple of justice equal protection of the laws." Later on, in July 2019, the additional building complex of the Supreme Court, where we are today celebrating this event, was inaugurated. The court's workload during the initial years was a fraction of what we witness today. In the annual report of 2005-2006, one of our former distinguished judges who is present here, Justice B.P. Singh, recounts that when he visited the Supreme Court for the first time in 1956, the proceedings were solemn and virtually dull. He also observed that at a time only 5 to 6 lawyers would be present in the court hall. Over the years, the workload of the Supreme Court has increased. Every day now, the Supreme Court has hundreds of cases on its docket. The judges of the Supreme Court and the staff of the registry put up tremendous work to ensure the speedy disposal of cases. Just to give you a simple sampling, in the last 3 months, 12,108 cases were filed before the Supreme Court. 12,471 cases have been disposed of. We have to also remember that the functioning of the Supreme Court was very different from the provincial high courts as they then existed. Many judges who are serving in the provincial high courts found it difficult to get accustomed to the new ways. When Justice Muhammad Hidayatullah was elevated to the Supreme Court in 1958, Mondays were miscellaneous days. Justice Hidayatullah's first day in court was a Monday. Late Sunday night, he found a huge bundle of 35 special leave petitions by his bedside. He was expected to have read them by the morning. However, Justice Vivian Bose, with whom Justice Hidayatullah was staying at the time, advised him to read only the later cases, because most of his colleagues would have only read the earlier cases, and that way he could control the conversation in the courtroom. Like Justice Hidayatullah, we, the bar and the bench, are also learning and adapting to the new norms on a daily basis. Over the years, the sanctioned strength of the court was increased, and currently it stands at 34 judges. As the number of cases increased, the court started sitting in smaller benches of 2, 3, and 5 judges. The Supreme Court's jurisprudential approach has been evolving. In the 1970s, the court adopted a broad, purposive, and contextual interpretation of the Constitution. In the past few years, the court has furthered the transformative vision of the Constitution by recognizing and protecting fundamental rights such as the right to privacy, decisional autonomy, and sexual and reproductive choices. Our court has emerged as a strong proponent of gender equality, whether it be in its interpretation of the laws of inheritance or securing the entry of women in the armed forces. The court has also ensured that the criminal justice administration is not delinked from the framework of human rights. For instance, while the death penalty has been upheld to be legal and constitutional, the Supreme Court laid down various mitigating and aggravating circumstances that a judge should take into account before awarding the sentence of death. This ensures fairness in the process. Procedural innovations, open court hearings in reviews arising out of death penalty cases, or psychiatric assessment of death row convicts have a humanizing influence on the law. Thus, the court has sought to use the language of the Constitution to humanize law and act as a protector and defender of fundamental rights and liberties.